Hello and welcome to a special edition of Legally Speaking with Tarun Nangia on UseX. Why is today special? Today is very special because of two special things. Today we launch the Legally Speaking digital series, a digital platform where lawyers and eminent jurists from all over the world will contribute articles as well as many other commentaries, judgments. A lot of things will be shared on this platform. Also, today we launch the Legally Speaking lecture series where every month we'll have one eminent individual lawyer or judge coming and sharing their opinions and observations, analysis on various topics. So indeed, today is a very, very special day. But what makes this more special is that we have with us his Honorable Mr. Justice Surya Kant, and we thank so much that Sir has made time for this very special occasion. And we've got, I think, the most high-powered and eminent legal panel that anyone could imagine. Getting so much time and so many people together, I think would cost a fortune. We count ourselves lucky that we have been able to get all of them at one place at one time. I would like to welcome Senior Advocate Mukul Rohatgi. He has served, as we all know, as the Attorney General of India, and he is counted as one of India's eminent jurists and is known all over the world as such. I have with me Dr. Abhishek Manu Singhvi. He is eminent jurist. He is also third-time sitting member of Parliament. He was former chairman, Parliamentary Standing Committee. He was also served as ASG. He is an author, commentator, and a well-known media personality. I have with me Senior Advocate Vivek Tankha from Kashmir to Madhya Pradesh. He is very well known, and his family is also very well known. He has served as the Advocate General of Madhya Pradesh, and he punches equally well in politics as well as in the courts. So he's got equal presence in Parliament. He's got equal presence in politics in Madhya Pradesh and equal presence in the court of law in Delhi. I have with me Senior Advocate Parag Tripathi. He has served as ASG. He's counted as an eminent jurist. And I have with me Mr. Ryan Karanjawala. Mr. Karanjawala heads one of India's leading litigation law firms called Karanjawala and Company, which was in the news very recently after the Tata judgment, which his law firm won. I have with me today on this very special occasion, Mr. Kartikeya Sharma. He is the promoter of ITV Group. ITV Group, as we all know, is one of India's largest media groups with well over 11 news channels, newspapers, digital websites, all to its credit. It's on this platform that we ideated Legally Speaking well over 4 years ago. And today, we are very happy to see that we have earned the confidence of the legal community, the bar and the bench, as they say, the bench and the bar both. So as we start today's discussion, first but foremost, in about a line, I would like Mr. Kartikeya Sharma at least to wish us well for this endeavor. He's wished us well in the past 4 years. If he could wish us well, I think we could do better in the next 4.
I will not take too much time of the esteemed guests we have and the Honorable Justice on board. And I would just like to welcome everyone on behalf of the ITV family. Thank you very much for taking out time and being a part of this on a very special day and special occasion. Thank you very much.
Thank you so much, Mr. Sharma, for those kind words of encouragement for all of us. We will start the initial opening remarks with eminent jurist, Senior Advocate, Mr. Vivek Tankha. He will open today's discussion, and we are all waiting to hear his intervention on today's topic of media and law. So, would you please open today's discussion?
Thank you so much. It's a pleasure to be here, and let me be short, not too long also. It's a very interesting subject, media and law. Now, if you look at media, you have to look at the media either in the old way, that is how the world looked at media earlier, that is what you call the Gutenberg era, or the Zuckerberg era. I mean, you have two eras. You have to now cling to the new era. Now, this new era brings its own issues, its own problems, and its own solutions also. Now, both are important for democracy. Media is the medium of thought and expression and knowledge. I'll put it also knowledge, because Article 19 protects media because it also disseminates knowledge. And law is important because it regulates, but it would not regulate knowledge per se. It regulates what could be the deleterious part of media, when it challenges public peace, when it challenges national sovereignty, when it challenges the establishments, establishment of the state. Now, we all have fundamental rights, but these fundamental rights can never be absolute. But yet, if you want democracy to survive, you need both. You need law and you need media. Now, what is this new world media? Because earlier, I believe it started with a radio. From radio, you must have, we went into wireless, and the first law on wireless came after Titanic sank, and the wireless system was not working. So the US legislature enacted the first law of wireless. Coming to India, after radio, we had Doordarshan. Now, all this was state-owned. Media, till a very large, till a very long time, was a state-owned enterprise. Even in a democracy, it was a state-owned enterprise. BBC is not owned by, really speaking, it's controlled by the government. It may not be owned by the government, it's controlled by the government. So media was never per se completely free. But this new era of digitalization, which you rightly said, has brought in its own issues. Today, you get knowledge through various platforms. Now, even like I'm an old timer, I read a newspaper in the morning. My children don't read newspapers. I've never seen them reading newspapers, but they know everything that I know, or maybe a little more, because on their laptop, they're reading everything. Now, if you look at the new platforms, I mean, today the digital media is the new media. Your OTT media is the new media. These are new platforms. Now, question is, how much can you control this media? These medias are on foreign platforms which are out of reach in terms of jurisdiction. It's not easy because, I mean, how are you going to control all this? World over, nobody's been able to control this. So the biggest challenge that the law is going to face is, you could control the traditional media by making laws in India, giving them notices of prosecution, giving them notices under the press under the PCI Act. Now, there is no PCI Act for the broadcasters. You have a self-regulator. We still have to have a law for the broadcasters in a sense. So what I'm trying to say is that this new world media is both an asset and could be a challenge at some point of time. Now, a lot of times you have sudden content being burst into a country's life, which creates unrest. I mean, I can share with this. I mean, we were in a parliamentary committee debating the new law that on the privacy. And one of the issues that we were asking all these media moguls and giants, that do you don't have a sense of responsibility when you put a content which leads to a riot, which leads to breach of public peace? How, if I can't regulate you, somebody needs to regulate you. I'm talking about, say, Twitter. or Facebook, they put a content that leads to a riot. And where do you prosecute them? And their regulation, they have a system of regulation, but that system of regulation, for that you have to make a complaint. They have a body which regulate, which goes into the complaint, but by that time the situation here would be too late. So there has to be a regulation. There is nothing like an absolute freedom, but freedom is essential. And I'm very happy. The other day I was discussing this with Karthike. Karthike is these days fantasizing about starting an international channel. So I said to Karthike, the best place to start it is India, because I think Indian judiciary is the most robust judiciary when it comes to freedom of press and press and media. I think if there is one judiciary in Asia which has stood by press and media, it is the Indian judiciary. Our contempt law is archaic. I'm 100% sure. In fact, it doesn't suit the present milieu. It doesn't suit us at all. We may bring in punishments. We may bring in other ways of controlling it. But to say per se that if you write against a court, you will be sent to jail, it doesn't fit into the new spectrum, the new thought process. And this is not India, I'm talking to the world over. Kind of reportage that you find in British and US newspapers about House of Lords and their Supreme Court and High Courts is amazing. I mean, you can't think of in India. But there's no such thing as contempt. But yes, when it comes to pornography, it comes to child abuse, all this, of course, has to be stopped. So as I said, it's a vast topic, unfathomable at this stage. I don't know how we are going to control them when their jurisdiction lies thousands of miles away. They're somewhere perched in a satellite or some platform which we can't even control. So it's a challenge, but an opportunity, because this new media has opened up job opportunities, new thought processes. I mean, frankly speaking, my two children are intimately connected with my daughter and my son-in-law with the with the digital industry. I mean, I don't even understand their work, frankly speaking, because they seem to be in a new world, a world which when I was young, I could not even think about. So we have entered a new world. We have challenges which this world has to face. We need to bring our laws in tune with the contemporary challenges. Parliament is debating it. Judiciary is thinking about molding these laws, but it will take time. Thank you.
Thank you so much, Mr. Tankha, for that analysis and sharing these words of wisdom with us. I would like to share an anecdote. Last week, in an interaction with a gentleman who served as the Chief Justice of India, he said that, let me assure you, at the level of the judiciary, we have always had the opinion that the media in India should self-regulate. We are in favor of self-regulation. We have no interest whatsoever in either the executive or the judiciary controlling the media. And in fact, these words of encouragement, in a sense, bolster. And I think these words also be music to the ears of Mr. Karthikeya Sharma, because even he has been a votary of self-regulation for the media, also in our association. So I think these are some things which makes us feel happy that the judiciary is why democracy exists. The judiciary is why freedom of press exists. And before we go on to the next panelist, I would also like to say that very gentleman also told me that you still cannot fathom the power of Indian judiciary and Indian judges. It is by far the most powerful in the world, or any which I have seen. So those were words which I heard just last week. But now I move on to our next panelist. I have with me Senior Advocate Parag Tripathi, eminent jurist. He's also served as the Additional Solicitor General of India, one of India's most sought after lawyers. Mr. Tripathi, if I could hear your words of wisdom on our topic today.
Yeah, as Vivek rightly said, this is a huge topic of media and the law. And one thing is very clear. Media lives, whether it is press or whether it is internet or electronic media, in perpetual and palpable tension with the other two principal institutions, that is the executive and the legislature. I would say 2+1 because of late that palpable and perpetual tension has also come up in media reporting of court proceedings. As we know in India, there is no specific freedom of press. It's a part of our 19(1)(a), which is freedom of speech. As an interesting aside, I can tell you that in the United States, in the original constitution, there was no freedom of press, no freedom of speech. They introduced it as the First Amendment. In India, the First Amendment was, ironically, to curtail the freedom of press and freedom of speech. And it was moved by no other than our first Prime Minister, who had thundered in the parliament that somehow we have found that this magnificent constitution we have framed was later kidnapped and purloined by lawyers. 5 of us are here already, so according to him, we were all guilty in different ways. So what was the cause for it? The cause was that the agenda of the government on which freedom had been obtained, namely land reform, zamindari, reservations, nationalization of industry, was all argued out and the challenges were upheld by the court. And then you had those two classic judgments in 1950 of Ramesh Thapar, which was a left-wing organization in Madras, which had carried out called Crossroads, a very trenchant, biting, personal criticism of the then government and the then Prime Minister. And Brijbhushan, which was the RSS entity called the Organizer, which had carried out an equally biting, trenchant criticism, including insulting criticism. Therefore, 3 more exceptions were added to the limitation under Article 19(2). The key to freedom of speech and the key to the exercise of freedom of the media is actually threefold. And it has been very aptly summed up by one of the great American constitutional lawyers by saying, the right to attack convention, the assault on prescribed orthodoxy. You shake up the prescribed orthodoxies, and the mockery of stuffed shirts. So stuffed shirts don't only mean the high class, it means the powerful class. This is the key of what freedom of speech is, and press is what freedom of speech is in action. Now, when you talk of free thought, whether it is from the press or otherwise, it is not only freedom of thought which those who agreed with us profess. It is freedom of thought, the thought which we hate. That is why the tension comes in. Otherwise, there is no problem. If everybody is going to say what I profess, where is the problem? Now, we therefore now come to our constitution, which was in a very fundamental way transformative. It was transformative because it gave independence to subjects who became from subject people to people who are sovereign people. And it reconstructed the state of society. It shifted power and power basis by reservation, by zamindari abolition, etc. Press, therefore, was the sentinel of all these changes. And not surprisingly, we have been called the constitution of a most surprising democracy. Now, press, which is really called the unsleeping guardian of every right that free men prize, there are 3 different aspects when we talk of media and the law. And when I say press, I don't mean the written press alone. I think my good friend Vivek used a very good expression from Gutenberg to Zuckerberg. So both the birds are included here and more. One is when media itself seeks protection from the other 2 institutions, that is the parliament and the executive. And where does it go for that protection? It goes for that protection to the court. And in India, for instance, there are several judgments, but I'll give one classic judgment, which is known as the newsprint policy judgment of 1972. The then government in power said that you cannot have more than X amount of newsprint. Your newspaper can't be more than 10 pages. A newspaper house cannot have new newspapers, etc. Now, prima facie, the question was, is it really a question of the freedom of press here or freedom of speech of the press? Because this is really more of freedom to do business. And the Supreme Court came to the rescue and said that this freedom of press has two elements. Qualitative, which of course we all know, that the right to think as you will and speak as you think. The qualitative and the quantitative. If you curtail the quantitative, if you only give me 2 minutes for newspaper news reporting, supposing I pass an order as an executive, then no news channel will have news reporting more than 2 minutes. That is a quantitative restriction, but it goes into the root of freedom of expression and press. So this is one element of tension where, as was pointed out in this meeting before we started, that Indian Supreme Court particularly and the High Court, the Indian judiciary has really upheld the rights of press in this country. Then is the question of citizens, that is accused and potential accused, seeking protection of court against the media. That's the other aspect. It's not just media and the court or media and parliament and media and the executive. It's citizens. So supposing X commits alleged rape or X commits some monetary impropriety. Now the problem is that if you're going to publish his photographs, supposing it's a normal crime, and you publish his photographs before the identification parade, or you publish write-ups about him saying this man has done this, this is his what are known as the famous leaks which happen from time to time. In his account, so much money has come from here. So by the time the matter comes before the court, there's a huge groundswell of public opinion. And this came up for hearing in the case of Manu Sharma, that is trial of media, whether it hampers investigation and right of the accused. So that's a balance, which is a case-by-case balance, which both media and the society has to take care of. The other aspect, of course, came up in the celebrated case of R.K. Anand, who was a senior advocate of one of our leading high courts, which is the propriety of sting operations. Because sting operations, which were in vogue about 10, 12 years ago, everything was a sting operation. It was a catch-all phrase, which covered everything. So the sting operations, of course, by definition, are based on deception. But the court said that doesn't mean that sting operations are necessarily to be excluded. Again, it's a question of a test, and you have to do that balancing on a case-by-case approach. The third aspect again came up in the Sahara India case, that is restraining press from reporting sub judice matters. And there came the doctrine which the Indian Supreme Court fashioned of postponement order. That is, you can report, but after a time lag, so that you don't influence either the investigation or the adjudicative process. Because after all, everybody is human. If I'm sitting and deciding something and I find that there's article after article, op-ed after op-ed saying this man is bad and he has to be literally hanged, then it has an impact on me. Of course, our judges are, by their learning and their discipline of 20 years plus on the seat, completely or largely oblivious. But for somebody like me, one would be very sensitive to how public is perceiving what you're doing. So this is the requirement to protect the citizen from the press. And then there is now the other aspect of the interface of press with court proceedings, court reporting, and responses to court judgments. These are two separate elements. One is of court proceedings and reporting. Today, what is happening is minute by minute, it's like a ball by ball commentary of a match. Minute by minute, the court asked this, Mr. So-and-so answered this, Mr. So-and-so interrupted and said this. Many, many times when judges ask a question, they are by no means expressing an opinion. They are just wanting to know. They're wanting to know, all right, what is it? Tell me, if it is like this, what will happen? If it is not like this, what will happen? So therefore, to read into it, particularly for a lay public, he or she will proceed on the basis that that's the view which the judge is expressing. It is not. It, in my view at least, affects that freedom of give and take. Many, many times in court, you have humor. sometimes that humor can be a little acerbic, humor can be a little dark. It would affect the ability and the atmosphere in the court if you know that everything which you say is going to be reported then and there. Therefore, it acts as an inherent restraint in thinking and that freedom which is so very necessary inside a courtroom. Uh, Therefore, on reporting, I think there has to be some kind. Of course, people have a right to know what is it. Let us say Mr. Rodgi argued, and how did he put it? Of course, people have a right to know. I would also like to know, but there has to be a line drawn somewhere. Otherwise, what will happen is that the freedom of thinking aloud, the right to think as you will and speak as you think, at least surely we have to grant that to our judiciary. That's the least we can do. That gets, according to me, compromised and affected. Then we come to the second and perhaps the last aspect of what I wanted to present today is this tension between the media and the court. Now, there are three things. One is a fair reporting. In a fair reporting, I can say that the lordships were totally wrong. They totally ignored these 7 propositions, which I think are determinative. This judgment is totally, totally wrong. Fair enough. No problem. Then comes a second category of personal insults, which is disgusting. There's no other word for it. It is disgusting. Does it run afoul 19(1)(a)? That's a very difficult question. Not everything disgusting runs afoul of the freedom of speech. And I give a very interesting example. In England, in the 80s, there was the in 87, there was the spy catcher case. They gave an injunction against the release of the book in England. There was no injunction in the rest of the world. So it was obviously a meaningless injunction. However, the Daily Mirror comes out with this famous photo of 3 judges with their faces inverted, head down, and says, "Old fools." So Lord Templeman was asked by one of the leading English lawyers, and he said, "Sir, why have you not proceeded against them in contempt?" He said, "Well, my lad, old we certainly are. And whether we are fools or not is a matter of perception. In my perception, I'm certainly not a fool. If some other gentleman thinks I'm a fool, good luck to him. Makes no difference." So this is one way of dealing with insults. That's very good to say that that is how it should be dealt with. But let us look inward. If supposing I'm arguing and my friend on the other side says, "What a stupid argument," I'll completely lose it. So we many times expect too high a standard when we test, when we say how the judiciary should react. Because as a human being, can you imagine your subordinate saying, "Sir, that's a very foolish argument, don't do it." That'll be the end of his stay in my chamber. So this is the second aspect, is of insult. That I don't think amounts to contempt, but it's disgusting, undoubtedly. The third is an area which comes to contempt, which is plain and simple contempt. And that is when you say, let us say that Mr. Tripathi was wrong and he was motivated and wrong. Now that is clear contempt. So that's the line which you have to draw. And it's a difficult line and it's an evolving line. It's actually a work in progress. So therefore, to sum up, as I said when I began, that press is in perpetual and palpable tension with the 2 other institutions of democracy, namely the legislature and the executive. It has been protected by the judiciary. And please remember, when the press or the media has a carping response to judicial judgments or judicial conduct, there is no defense which the judiciary has. Because it is not only the judiciary. Contempt is, of course, against the judiciary. But it is, you're also attacking an individual judge. He can't hold a press conference and say that, "Look, what you have said is wrong." So his remedy is not there. Now, it is very well to say chin up and face it. But that's not the way a healthy democracy should function. So it's time for introspection, for us to find out ways and means. And yes, as was pointed out, self-regulation is one way. Absolute freedom is certainly not there. But as we have shown as a nation in our response to COVID, we lack a lot when it comes to self-regulation. So it's time that we really gave it a serious look and moved forward. Thank you so much.
So thank you so much, Mr. Tripathi, for these words of wisdom and also the kind of thoughts that you shared with us.